Next up, we're going to have Professors Robert Williams and James Anaya. And I would ask that we give them respect of listening to what they have to say and their perspective. They are going to present jointly, so they will have 1 hour. And I know it's not usual for us, for our people, to sit back and listen. We like to engage, but as best we can, if we can let them continue with their presentation and make it to the question and answer. First off, Professor James Anaya. He's well known. He was required reading in my law classes in school. He teaches and writes in the areas of international human rights, constitutional law, as well as issues concerning indigenous people. He also received his law degree from Harvard and his undergraduate from the University of New Mexico. He has recently completed a term as a special rapporteur on the rights of indigenous people at the United Nations from 2008 to 2014. He is on the faculty of the law school at the University of Arizona. He's lectured in countries worldwide advising indigenous and other organizations on human rights and representing indigenous groups from North and Central America in landmark cases before courts as well as international organizations. One thing of importance to some of us here is he helped draft the United Nations Declaration on the Rights of Indigenous Peoples, otherwise known as UNDRIP. And he was also the lead counsel for the indigenous parties in the case of Awaz Tingi versus Nicaragua. American Court of Human Rights for the first time upheld indigenous land rights as a matter of international law. As a UN Special Rapporteur on the rights of indigenous people, he also monitored the human rights conditions of indigenous peoples worldwide and addressed situations in which their rights were being violated. He's also promoted practical measures to secure indigenous people's rights. So mahalo for coming. I'm also going to introduce Professor Robert Williams. He is Lumbee. And in addition to several other books, he has also written acclaimed books such as The American Indian and Western Legal Thought, The Discourses of Conquest, which has received the Gustavus Myers Human Rights Center Award as one of the outstanding books published in 1990 on the subject of prejudice in the United States, as well as Linking Arms Together, American Indian Treaty Visions of Law and Peace. He has also represented tribal groups before the Inter-American Court of Human Rights and the United Nations Working Group on Indigenous Peoples, and has served as co-counsel for Floyd Hicks in the United States Supreme Court case Nevada versus Hicks. He's also served as Chief Justice for the Court of Appeals for the Pascua Yaqui Indian Reservation, and feel free to correct me, I apologize, and as Justice for the Court of Appeals and Trial Judge Pro Tem for the Tohono O'odham Nation. Okay. He was named one of 2011's Heroes on the Hill by Indian Country Today for his work on behalf of the Hokumi'umi treaty group before the OAS Inter-American Human Rights Commission. Thank you both for being here.
Good morning. Aloha. It's great being here in your land in Hawaii once more. I want to thank the Office of Hawaiian Affairs for the invitation to be here, and thank all of you for allowing me to be among you and share some thoughts. I come here with humility, not being one well-versed in your day-to-day struggles, not being one among you who has the responsibility for defining the path of your futures, not being one responsible for taking those difficult steps that are before you to define that future of self-determination and of the realization of those aspirations that your ancestors handed down to you and that you are living. Unlike Professor Boyle, and I must say I agree with much of what he said, I'm not here to suggest to you or tell you what it is you need to do along this path of self-determination, nor can I speak as one of you, not having been adopted as I believe he has been among you or within one of your groups. Again, I come here to speak as an outsider on the basis of a research project that the University of Arizona Indigenous Peoples Law and Policy Program that I am co-director of, along with my colleague Robert Williams. We've been asked to do research by the Office of Hawaiian Affairs on specific questions in the context of the proposed federal rule for the establishment of or reestablishment of a relationship with the government of Hawaii. And alongside that, also, this is in the context of initiatives to reconstitute or reclaim the government of Hawaii, or for the Kanaka Maoli. And so I'll be talking about, with the two of us will be talking about issues having to do with the specific questions that have been put to us by the Office of Hawaiian Affairs in the context of this research project that we're engaged in. We'll be talking primarily about the international system for the protection of the rights of indigenous peoples in particular. Now, I understand that many among you may not regard this system of protection for the rights of indigenous peoples as specifically relevant to you, or that you may see other aspects of the international system as relevant also, or more relevant to your claims. But I simply ask you to bear with me and allow me to go forward with what I have to present along these lines. And of course, it's up to you to decide the extent to which what we are going to present is relevant to your situation or useful to it. And we'll be talking about things that many of you are already familiar with. So again, we ask for your indulgence. Again, thank you very much for this opportunity, and we both look forward to the discussions that we're going to have with you after our presentations. The specific question that has been put, one of the specific questions that has been put before us is as follows. We've been asked to give an overview of the extent to which the United States and its political subdivisions, including the state of Hawaii, has an obligation to recognize indigenous peoples under international human rights standards or international standards that are reflected in the UN Declaration on the Rights of Indigenous Peoples, written instruments and jurisprudence of the American human rights system, UN treaties that are binding on the U.S., and other relevant international sources of authority. Many of you are familiar with the United Nations Declaration on the Rights of Indigenous Peoples, which was adopted by the UN General Assembly in 2007. This picture is taken at the exact moment that the vote was taken. You see up on the voting board the votes of the overwhelming majority of UN member states that cast affirmative votes in favor of the declaration. Unfortunately, there were 4 that voted against, and 1 was the United States. However, in 2010, the United States, through a statement by President Obama, reversed position and endorsed or declared support for the declaration. So we can see, as did the other 3 countries that had voted against it, they reversed their positions as well. So we can see that the declaration represents a significant consensus by the state and UN member states and by the international community more broadly. At this precise moment when the vote was taken, the world passed from a time when the rights that had been promoted by indigenous peoples or advocated by indigenous peoples on a global scale were aspirational to a time in which they were affirmed by the world body, the UN General Assembly. The declaration proclaims that all individuals and peoples are equal, including indigenous individuals and peoples, making a statement against the histories of discrimination that indigenous individuals have suffered for centuries, and certainly since colonial times, discrimination that I'm sure many of you could speak to in a very direct sense. It affirms the right of all peoples, including indigenous peoples, to self-determination in the exact terms that the right of self-determination is affirmed for other peoples, all other peoples in other international instruments. And with that right of self-determination, the right to self-government over matters of importance to indigenous peoples, particularly with regard to their own affairs, is affirmed. Along with self-determination and self-government, related principles of of culture, cultural integrity, rights over lands and resources are featured prominently in the Declaration. very important are the provisions of the Declaration having to do with lands and resources, which recognize indigenous peoples' own modalities of use and occupation of lands and territories, recognizes indigenous peoples' own forms of properties on an equal basis with all others, and calls upon states to protect and respect those rights. Important features of the Declaration is that it provides recognition, it expresses recognition of the historical and ongoing denial of the very rights that are expressed in the Declaration. Indeed, the Declaration manifests itself as an instrument that owes its existence to the fact that these rights have been denied historically, again, as many of you could attest in a very direct sense. And hence the Declaration makes a call for affirmative measures, specific positive measures, on the part of individual states and the world community at large to make these rights a reality, to reverse the tide of history, to reverse that tide of history of oppression of indigenous rights towards one in which indigenous peoples are in full enjoyment of their rights. We are yet at a time on a global scale where these rights are being realized in the lives of indigenous peoples. We are still at a time when the Declaration is more of a reminder of a denial of these rights than a reflection of the reality in indigenous peoples' lives. But the Declaration stands as a challenge to the world, a challenge to the states of the international community to take affirmative action alongside indigenous peoples, in cooperation with indigenous peoples, to make these rights a reality. Essential characteristics of the Declaration are first, that it is a human rights instrument. The principles that are affirmed in the Declaration are based on fundamental human rights of universal application, but taken in the specific context of the realities of indigenous peoples. So it is not just the individual rights of indigenous peoples that are affirmed, but also, and moreover, the collective rights of indigenous peoples that are affirmed. So the right to language as a part of the right to culture is viewed not just as the right of an individual to speak language, which doesn't make sense, or a whole lot of sense, but the right of the collectivity, the people itself, to speak that language and to develop that language and have that language respected in the life of the community, or the community that they live. The Declaration also is expressive of the human rights obligations that the United States and other countries have under the United Nations Charter. The UN Charter obligates states to take specific steps to promote human rights on a non-discriminatory basis. The Declaration helps the UN states understand, the UN member states understand what those specific human rights grounded in the Charter are. And they include the rights of indigenous peoples. The Declaration is also expressive of rights that can be seen in the treaties to which the United States is a party, such as the International Covenant on Civil and Political Right and the International Convention on the Elimination of All Forms of Racial Discrimination. These are two important human rights treaties that affirm important principles such as the right to self-determination, the right to culture, the right to life and dignity. And the International Convention on the Elimination of Racial Discrimination features prominently, of course, the right to non-discrimination, the right to equality. And both these treaties have been interpreted by relevant UN bodies, relevant United Nations bodies, as having specific implications for indigenous peoples. The right to self-determination has been linked to a series of entitlements and rights that indigenous peoples have to maintain their identities, to maintain the integrity of their cultures, and to pursue their own futures according to their own designs. The right to culture that's affirmed in the International Covenant on Civil and Political Rights has been interpreted to have specific meaning for indigenous peoples, to embrace and protect all aspects of culture that define indigenous peoples, including the relationships with lands and territories and the natural world more broadly. The right to non-discrimination, as affirmed in the International Convention on the Elimination of Racial Discrimination, has interpreted to mean that indigenous peoples have the right to equal treatment with regard to all those aspects of their distinct identities, including their political lives, the political institutions that make up their communities, their relationships with lands and resources. Though the committee in charge of interpreting and applying the Convention on the Elimination of Racial Discrimination, CERD, has taken that discrimination, that norm of discrimination, to mean that states have a duty to repair the historical acts of discrimination that indigenous peoples have faced, including those historical acts that have resulted in the dispossession of their lands and resources. Now, the Declaration stands as the most prominent expression of the rights specifically of indigenous peoples today. and with that, a statement of the obligations that states have with regard to indigenous peoples. And with that, the obligation to recognize indigenous peoples as having their distinct identities as such and having particular rights as indigenous peoples. The Declaration is not alone within the international system for the protection of indigenous peoples' rights. As I said, it is expressive of those rights, but it is related to human rights principles more broadly and hence related to other international instruments. I've already mentioned a couple, but there are also the instruments of the Inter-American System, which are the American Declaration on the Rights and Duties of Man and the American Convention on Human Rights. The Declaration being within the system that is most the United States. The Inter-American institutions have developed a jurisprudence that is a series of decisions based upon these inter-American treaties or declarations, specifically concerning indigenous peoples. Mention was made in the introduction of the Awastini case that went to before the Inter-American Court of Human Rights. The Awastini case is a case in which the court affirmed that the general right to property that applies to everybody has specific meaning for indigenous peoples. That understood in a non-discriminatory manner, property includes indigenous people's own property systems. And hence the court in that case affirmed that the property system of the Awastini indigenous community, based on their own customary land tenure, even though the government was denying that right to property, was a property interest protected by the American Convention on Human Rights. And hence the court ordered Nicaragua in that case to recognize the indigenous people as such, recognize their right to property over their lands and resources according to their own traditional land tenure, and to take specific measures to secure those property rights and other interests in relation to the traditional lands and resources. And then there are the authoritative interpretations of other international treaties by UN bodies, and I've already mentioned those in connection with the International Covenant on Civil and Political Rights and the International Convention on the Elimination of Other Forms of Racial Discrimination. There are a number of other international instruments that also mention indigenous peoples and in one way or another affirm principles related to indigenous peoples and their rights, and these would include International Labor Organization Convention number 169 on Indigenous and Tribal Peoples, which affirms indigenous peoples' institutions, rights to equality, rights of participation, rights over lands and resources, and rights to social assistance and development assistance by the international community and by the states within which they live. The International Labor Organization Convention number 169 has been widely ratified throughout the Americas. It has not been ratified by the United States, but nonetheless it sets an important benchmark for the recognition of indigenous people's rights at the global level and can be seen as complementary to these other instruments and developments that I've mentioned, all of which manifest and represent a special regime of international law, international human rights law, focused on indigenous peoples. This regime obligates states, including the United States, to recognize indigenous peoples based upon their historical use and occupancy and presence in their traditional lands, based upon their distinct identities and the situations that they find themselves in with regard to settler populations that have grown up around them. States are under an obligation to recognize indigenous peoples within these instruments and in this regime, and under an obligation to recognize these rights that I've laid out, these rights of equality, these rights of self-determination, self-governance, these rights of culture, rights to culture, and rights over lands and resources. Now, a part of this first question that we've been asked to ask is, we've been asked to give an overview of good practices under the various modalities the state and its subunits may utilize in this regard. That is to recognize the ways, good practices having to do with the ways that nation states and their subdivisions can recognize indigenous peoples and their rights. And so what we're doing in this part of the research is to lay out examples from other parts of the world in which states or governments have taken action roughly commensurate with instruments to recognize indigenous peoples and instill or put in place protections for their rights. Now, one example is the constitutional and legislative recognition of indigenous peoples that we see throughout the Americas. Going back to Nicaragua, beginning in 1986, Nicaragua became the first, or one of the first countries, I believe actually Guatemala preceded it, to have specific constitutional recognition of indigenous peoples in the country and certain basic protections in their rights within the Constitution. So the Nicaraguan Constitution recognized the indigenous peoples, particularly of the Atlantic Coast region, and their rights to autonomy. And on the basis of that, legislation followed. Now, the fact that Nicaragua had this in the Constitution and legislation didn't mean they automatically respected those rights. Again, it's one thing for these rights to make their way into the law. It's another way to see those rights applied and made effective. And many times, the international standards and processes interact with the domestic ones in order to see these rights implemented. And that's what we saw in the Awastini case that made its way before the Inter-American Court. Nicaragua did not respect the rights of indigenous people according to its own constitution, and hence the Awastini case, where Nicaragua was in fact violating those rights, made its way to the Inter-American Court. The court ordered Nicaragua to, as I said before, implement those rights over lands and resources, both in accordance with its own constitution and in accordance with the international standard. That helped to generate a process by which those rights eventually are becoming implemented. That case then illustrates the interplay between the international standards and the domestic incorporation of those standards within specific modalities such as a constitution. We also see, in another example, constitutional and legislative recognition of the Sami indigenous peoples in the Nordic countries. The Sami people, many of you may know Sami individuals. They've been very active nationally. I'm sure some have visited here. They are the indigenous peoples of the far northern part of Europe or Scandinavia. They are in Norway, Sweden, Finland, and parts of Russia. And each of the Nordic countries has provided specific constitutional recognition of the Sami people as indigenous peoples and constitutional recognition of the right to maintain their culture. And with that, legislation that has recognized and helped to the Sami people to establish governance institutions, namely the Sami parliaments. And so there's legislation that provide for parliamentary bodies through which the Sami people can administer various programs that are of concern to them. There's also legislation, at least in Norway, protecting land rights, and there are initiatives in the other countries for legislation providing further recognition. Another example many of you are familiar with is the recognition of the Maori people in New Zealand. This is in relation to the Treaty of Waitangi, an historical treaty of 1840 between the British Crown and Maori chiefs in representation of the Maori people. And this provides a framework for accommodation of the Maori people and the settler people, a framework around which current discussions have been furthered to recognize Maori interests over their lands and resources, self-governance, and the rights to reparations for violations of their rights historically. Judicial recognition of the Maya people and their rights in Belize. In Belize, we've seen, as in many countries, governments simply ignoring the rights of indigenous peoples over their lands and resources. The Maya people took the government of Belize to court in the domestic arena. And there are now a series of decisions by the courts of Belize affirming, recognizing the Maya people as indigenous, as being the original owners of the territory, and recognizing on the basis of that their rights over lands and resources, and ordering the government of Belize to take specific action to protect those rights. Now, the most important of those decisions is now on appeal before the Caribbean Court of Justice. That appeal will be heard early next year, and so that will result in, I think, in a very important precedent one way or another. And then a final example I want to mention that is going to be further elaborated upon by my colleague Robert Williams is the recognition of the Kanak and their rights as indigenous peoples through the Noumea Accord within the framework of the decolonization of New Caledonia. New Caledonia is a so-called non-self-governing territory under French administration, under the French Constitution. It's regarded as an overseas collectivity or overseas territory with local autonomous powers. The Noumea Accord resulted after conflicts between the Kanak indigenous people and the French, and it sets in place mechanisms for recognition of indigenous people's rights and coexistence of the Kanak and the other people. And it also sets in place a process towards decolonization or further decolonization and eventually a referendum on potential independence. What we see in this example is the intersection between the international system or regime for the protection of indigenous rights and the international regime of decolonization, that is the system that exists internationally for the decolonization of what are regarded as non-self-governing territories. And I want to say a little bit about that intersection in a moment, but first let me point out what I see as the two important factors that exist to one degree or another in these two examples that lend to the legitimacy of these mechanisms of recognition of indigenous peoples and their rights. One factor is the extent to which indigenous peoples have participated in these mechanisms of recognition. And that varies in these cases. But the most legitimate of these mechanisms are those in which indigenous peoples have been full participants in the definition of these mechanisms. In the case of the Sami, we can say that the Sami were indeed involved very much in the development of the constitutional protections and very much involved in the development of the Sami parliaments, so that those mechanisms can be seen as their expressions of how they saw the modalities of recognition of their rights best achieved. In the case of the Noumea Accord, of course, in the case of the Kanak people in New Caledonia, that was indeed an accord, a negotiated agreement between Kanak leaders and the French authorities. Other of these examples similarly have varying degrees in one way or another of indigenous participation in the definition of that modality. So one factor that lends to the legitimacy of these examples is the extent to which indigenous peoples themselves participated in the design of these mechanisms. Now, another factor, of course, is the extent to which these mechanisms actually do, in a substantive way, recognize and make effective indigenous people's rights. And here we see a lot of variance. The Nicaraguan constitutional mechanisms provide certain minimal recognition for indigenous people's rights, but not in a very robust way. There's still a lot to be done to build up the constitutional legislative recognition there. The same can be said of each of these different examples. There are certain protections put in place, but are they enough? I would say that in each case, no, there's not enough. But those two factors are important to keep in mind in any the ones who participate in the development or articulation of the modality or the mechanism and the extent to which those mechanisms actually do in a substantive way protect indigenous people's rights. Now, as I said, the distinct from the international protection for indigenous people's rights in particular is the decolonization regime. This is a system of standards and processes put in place by the United Nations on the basis of Article 73 of the UN Charter to provide for the supervision of the decolonization for territories that have fallen under colonial domination. These territories have been referred to in the Charter in Article 73 in particular as non-self-governing territories, territories that aren't where the people aren't in full control of their affairs. Rather, the colonial power is in one way or another in control. Article 23 provides for mechanisms to promote the decolonization of these territories through specific remedies that include one of three or choices along the lines of these three options. That is integration within the state on an equal basis, free association or freely associated state, autonomous but associated with the state, yet some still independent, and then full independence. These are the options that have been promoted through the decolonization regime. Important factor is the choice of the people concerned. Any of these remedies for to do away with colonization, integration, association, or independence is acceptable as long as that outcome results from the choice of the people concerned. But to keep in mind with one thing to keep in mind with the decolonization regime is that it focuses on the people of the entire territory within the non-self-governing territory, so that it is generally all of the people, and not just particular groups defined by ethnicity or that get to vote. So in the case of Hawaii, Hawaii was on the list of non-self-governing territories and went through the process, or a process, under Article 73. There was a referendum by which the people living in Hawaii, let's say, were allowed to vote, and the choice was between statehood and continued association as an autonomous territory. Now, the choice was for statehood. Now, there's a problem there, of course, right? That vote, however much it embraced everybody, or most people living in the territory, didn't really respond to the original inhabitants of the territory, to the Kanaka Maoli and their aspirations. And the choice that was provided didn't include the option of independence. So my view is that that was an incomplete step in the decolonization process. That was an incomplete step in the decolonization process. And the same is the case for many other territories. So that in New Caledonia, for example, Tahiti, however many steps or however much there have been processes towards decolonization, that process is still incomplete. And so Tahiti, or French Polynesia, and New Caledonia have been put back on the list of non-self-governing territories, and again under UN supervision pursuant to Article 73 of the United Nations Charter. Now, as I said, the indigenous rights regime is distinct, right? It provides a specific focus on indigenous peoples, not just the people of the entire territory. But it is a complement. It is a complement to the decolonization regime. And we can see this in New Caledonia, where we have simultaneously a process towards the decolonization of the entire territory, in which all the people of the territory with substantial roots in that land are entitled to participate. So that New Caledonia, the vote on the upcoming referendum on independence will include as its electors, as the people entitled to vote, all the people living there for a generation, more or less, for 20 years, otherwise with substantial roots, including people who are the descendant of French settlers. Not just the French, not including the French people who just got there 10 years ago, but the people who were the descendants of French settlers at least 20 years ago. It would include all those. Yet at the same time, there's specific focus on the rights of the Kanaka indigenous peoples and specific protections being developed for the Kanaka indigenous peoples, including protections for their customary laws, their rights over lands and resources, and their authority structures. And those are included within the Noumea Accord and the framework for New Caledonia. So we can see the indigenous rights regime as being complementary to the decolonization regime. So that even if we can say that, in a sense, decolonization has been achieved by the emergence of a new state or its integration within a larger state, it's not complete until the specific rights of indigenous peoples are addressed, affirmed, and protected. So now we're going to talk about relevant procedures that exist with the international system for the implementation of these rights, and that will provide for the basis of claims on the part of the Hawaiians and others for the violation of these rights. And my colleague Rob Williams will address that.
Thank you, Jim, and aloha, and thank you to the organizers of this conference for inviting me to speak here. I'm honored and both humbled. Also, I want to acknowledge the contributions of Professor Boyle. Like Jim, there isn't anything I would disagree with what he said. In fact, after his speech, I wished I could give his talk rather than the one I have to give. And I wish I could be adopted to join the struggle with you guys. It's where my heart and my mind is. But we were asked specifically to study the Interior Department proposed regulation and look at it from an international law perspective. And that's what I want to do here very briefly, is run through some of the mechanisms within the United Nations and OAS human rights system. I have to tell you that in researching these various mechanisms, you guys were here all the time. And I've been involved in many of these mechanisms, and I have to say that Native Hawaiians have used these mechanisms most effectively. In fact, oftentimes, to make very effective arguments for the restoration of the monarchy, independence, decolonization. And while many of these mechanisms have the word indigenous in them, what you've discovered is that they can be very effective platforms to make your arguments. They've opened up a space. You've used them as a tool to put forward a number of different arguments. And I think these mechanisms can continue to be used even if the decision is made to go ahead with this Interior Department regulation. Why use these mechanisms? Well, I think for many of you, I've actually seen some of you over in Geneva and at New York. Why use these human rights mechanisms? They promote awareness of human rights violations. They expand the scope of human rights protections and open up a discursive space in which you can make your arguments for independence, restoration, decolonization, or even if you want to be an Indian tribe. They hold governments accountable for upholding human rights, and they provide important venues for telling your story. And I can tell you I've heard many Native Hawaiian speakers at these venues telling their story, and they're very effective storytellers. And they do win hearts and minds. And so I'll just run through these quickly because many of you are familiar with these mechanisms, but again, they're tools, they're part of the toolbox. And to me, the question isn't whether you pursue restoration, independence, decolonization, or the equivalent of some sort of reservation status. To me, the question is whether or not this proposed rule can provide you another tool for trying to achieve your aspirations, however you interpret them, for self-determination. And having looked at the proposed regulation, there's nothing in that regulation in and of itself that would preempt you from pursuing your vision and telling your story of where you see yourselves headed as a nation. In fact, in many ways, this particular mechanism may well provide you another platform to engage directly with the U.S. government and make your assertions and make your arguments and organize in a way that would not be available otherwise without this idea. And so, United Nations Permanent Forum on Indigenous Issues. Again, the I word is there, but it's been freely open to advocates from Native Hawaii to make their arguments, and they've been embraced and accepted. My colleague James just stepped down from 6 years as United Nations Special Rapporteur on the rights of indigenous peoples, was very much involved in issues respecting Native Hawaiian rights, sovereignty, independence. Wrote letters to the United States government, still waiting for a response from the government on the argument that the overthrow was illegal, calling the government to task. Again, an example of how a special rapporteur on indigenous peoples can be utilized as a tool by Native Hawaiians to get their arguments out there and put them in the face of the United States government and win the hearts and minds of countries as Professor Boyle outlined. These are important platforms. Were these platforms not there for you, and had you not used them, would your movement be where it is today? I don't know, but I think I know the answer. I think they've been tremendously helpful. The UN Human Rights Council is another important forum, particularly the expert mechanism on the rights of indigenous peoples, which basically supersedes the UN Working Group, which led to the drafting of the UN Declaration on the Rights of Indigenous Peoples. This mechanism has the ability to promote studies and research on important issues, and again provides another important platform and tool for you to voice your aspirations and to get those opportunities to make the types of arguments Professor Boyle was making. And you have used them, and I would urge you to continue to utilize them for whatever decisions you come to as a collectivity. at a level not necessarily limited to indigenous issues, the Universal Periodic Review process of the Human Rights Council. You'll note there that the United States is coming up again for review in 2015. It's a very open process. I've come across numerous shadow reports written by Native Hawaiian advocacy organizations raising the issues that we heard talked about today in a very powerful and effective fashion. And then finally, UN CERD is another mechanism that has been utilized quite frequently by Native Hawaiian advocates, providing for periodic review of the United States performance on its human rights obligations under the CERD Treaty. Yeah. Finally, one particular set of institutions I've been much involved in is the Inter-American Commission on Human Rights as part of the OAS human rights system. The cases that Jim mentioned have been in the forefront of defining rights of self-determination and control over property and other important cultural rights, and have actually contributed significantly to the standards articulated in the UN Declaration on the Rights of Indigenous Peoples. It's a very open forum. It requires the government to engage you in a litigation-type posture where you can submit your arguments and your evidence and the government has to respond, and a group of independent human rights international law experts are there to evaluate those arguments and to assess whether the U.S. has lived up to its treaty obligations under the OAS Charter. So with that, I'll turn it over to Jim, who's going to talk about pursuit of a domestic remedy.
Okay, the next question we've been asked to address is the pursuit of a domestic remedy along the lines of the proposed federal-state administrative process and its effects on potential remedies and forms of redress in relevant international forums. That is, are these two things somehow conflicting? If Native Hawaiian people pursue remedies under the domestic scheme or in relation to the proposed federal rule for some form of government-to-government relationship, does that somehow undermine the claim for sovereignty at the international level? Our view is that it does not. The international system is such that claims, particularly with a human rights foundation, are preserved unless they're specifically given up. So that unless there were some waiver, that is, unless there was some definitive expression on the part of the Hawaiian people that by pursuing the federal recognition or the federal government-to-government relationship in some way, that gives up the rights that would otherwise be claimed at the international level, those rights are not given up. That right is not given up. Not as a legal matter, they're not given up. They might admittedly undermine the political steam that one has. It might suggest to some that, well, we don't have to worry about going to the international system or seeking that sovereign status internationally because we have this other thing. But as a legal matter, it doesn't impede those claims unless there is a waiver. That is a specific statement that those rights are being given up. Or unless, in fact, or the extent to which the federal government-to-government relationship settles all those claims. And my guess is that that would not be the case, that definition of a settlement of a government-to-government relationship with the federal government under the proposed administration rule would not settle all these claims. And so, really, the question is one of strategy. The question is one of strategy. And to keep in mind is that the international procedures, in fact, exist to encourage movement at the domestic level. Even in the case of decolonization, it's up to the administering state, that is the country and its government that is in effective sovereign power, to move towards decolonization. And that country has the responsibility to report to the United Nations mechanisms. There's no United Nations body that grants independence to non-self-governing territories. It's up to the country at the local level, in cooperation with the people concerned, of that territory to work towards decolonization. And so, if anything, what the international system does is encourage these domestic processes and to help move them along so that, in any case, some movement at the domestic level is required. And in fact, one can think of a scenario that rather than prejudice those claims, that is, undermine them, any kind of building of a Hawaiian government, reconstitution of Hawaiian government, can help strengthen the foundation for that exercise of sovereignty, which then in turn strengthens that claim for recognition at the international level. And this is the lesson that we have in some of the cases that Professor Boyle mentioned. For example, in the Catalans in Catalonia in Spain. They are claiming they are going to have a referendum for independence next week. And what they've been able to do over the past 20 years is build up their self-governance capacity within the framework of the Spanish constitutional arrangement. And by exercising self-governance power, they built up legitimacy for their claim of independence. So the exercise of authority locally that might come along with some form of federal recognition according to the rule that's being laid out could, in fact, build the case for international recognition of sovereignty. Now, I will disagree with Professor Boyle on what the federal proposed rule says. The rule says nothing about becoming like an Indian reservation. I urge you to read it carefully. It is open-ended. It provides the possibility for you to define. It specifically provides the possibility for you to define it. Now, someone else might say that's what the U.S. has in mind, but what matters is what you have in mind. How are you going to move along that process? The rule does not define specifically what the outcome is. It opens the door for a discussion about what form of recognition there will be. Now, finally, let me just note that Article 45, the UN Declaration on the Rights of Indigenous Peoples, says specifically, nothing in the Declaration may be construed as diminishing or extinguishing the rights Indigenous peoples have now or may acquire in the future. So that is what that provision provides, is that it reflects the rule that as a matter of international law, the exercise of rights as Indigenous peoples under the various sources we've discussed do not prejudice claims that Indigenous peoples may have under other sources of international law.
So building on what Jim has just talked about, give an overview of good practices with respect to procedures that have been used by states to constitute the governing entity. In other words, to establish a government-to-government relationship. And again, the point I would make is that along with the international mechanisms that I briefly surveyed, it may well be that Native Hawaiians have the ingenuity and are cautious enough to think about using this process as a way, another tool, to advance their claims to whatever self-governing, self-determining status they decide. As Professor Boyle noted, you may well be on a quarter-century journey. And maybe during that time that you might be able to use this process as a way to build your governance capacity and strengthen your arguments to all those governments that you need behind you to support your own aspirations for self-determination. It's a lot easier to convince a government, to convince a state to recognize you if there's a governing authority on the ground. That's as true for Palestine as it is for Native Hawaiians. And so one thing to think about is a range of possible options should you decide to enter into this process, as Jim says, and open the door. And you can close that door at any time. And you have plenty of reason to be suspicious of the United States. You ought to enter into that room at arm's length bargaining position and recognize that the world is watching. And so I've outlined what I call 3 different processes that are part of our study: the good, the bad, and the ugly. And as you step into this process, you ought to learn from the experiences of other groups who've had very similar aspirations like yourself, and have either negotiated with their governments deals that they feel good about and meet their legitimate aspirations, or have negotiated deals that they're sorry about and need to go back and perhaps redo. So the good would be the example that Jim talked about, New Caledonia, which used the decolonization process as a platform now to launch their legitimate bid for independence. Without that decolonization process and that intermediary step of self-governance delegated by France, they wouldn't be in the position where they're at today. Right now, their status is between, I'll go to them in a second. So, the second one would be the Maine Indian Settlement Act. And these people were turned into an Indian tribe. They were Indians, but they were not federally recognized. And in the 1980s, they brought a claim. And that claim ended up in a settlement act. And some decisions were made that they regret. There's a lot of lessons that can be learned from that settlement act. In fact, if you take a look at that settlement act, it echoes some of the provisions of the Akaka Bill. So you might want to look at it very closely. That's why I call it the bad. And then there's the ugly. And we have a process going on in Canada right now where the Canadian government claims it is trying to meet the self-determination aspirations of First Nations in the province of British Columbia. But the process is a disaster. And again, I think there would be important lessons for Native Hawaiians to learn by looking closely at that process. So New Caledonia, just going through some of the possibilities. These are some of the possibilities to think about. It's a menu. It's a set of tools. Federal recognition. Or rather, statuses in between that. I can't read up there, so I'm going to read off mine. It remains part of the French Republic. The status is in between that of an independent country and overseas collectivity of France. It has a territorial government and Congress. Under the 1998 Noumea Accords, as Jim talked about, key areas such as taxation, labor law, health, hygiene, foreign trade are controlled by that territorial Congress. They negotiated those self-governing powers. They did not have them before, but they were willing to open that door and seize those powers. And they've also got agreements that further powers are to be devolved to this Congress in the future. They're even negotiated the ability to pass statutes that are contrary to French law in certain areas. There's a New Caledonia citizenship that's been introduced. Only New Caledonian citizens have the right to vote in local elections. French citizens living in New Caledonia who settled in the territory recently do not possess New Caledonian citizenship. There's a precedent you can cite in your negotiations with the federal government. It's not some harebrained, wacko idea. It was accepted by France, of all things. And you also have the ability, New Caledonians have the ability to engage in international cooperations with countries of the Pacific Ocean. These things weren't given to New Caledonia. They negotiated for it based on their human rights to self-determination. And this is how they use the process. Again, echoing Jim, it's up to you how you use the process and what you ask for and what you'll settle for and what you'll negotiate. But nobody can force you to accept an extinguishment of your rights. Interestingly, under their status right now, they remain part of the French Republic. They have representatives in the French National Assembly, 2 senators in the French Senate. They remain right now as inhabitants, citizens of France. They carry French passports. They take part in the legislative and presidential elections of France. What you can see is a very flexible model, that you're not locked into one method. You're not locked into one mechanism. You have the choice as part of your right of self-determination to decide which of these powers are important to you now, which of them you might be ready for in 5 years, which you might be ready for in 10 years. Maybe you will be ready. Maybe you make that choice in 25 years for independence. But you can see how this self-governing process, this establishment of a government-to-government relationship can provide you an important platform to get to where you need to go. Okay. Again, the Maine Indian Settlement Act. Take a look at it. It has some provisions in there which will sound very familiar to those of you who oppose the Akaka Bill. The Indians got federal recognition, and that gave them access to important services such as housing, health, and environmental management. However, the act expressly extinguished any further tribal land claims and legally ratified and removed any obligations of the state with regard to any previous land transactions. They're sorry they did that. They got bad advice from their lawyers. They probably wouldn't make that same concession right now. Learn from that experience. They're provided with a settlement fund, $26.8 million apiece. the first 150,000 acres of land purchased would be held in trust by the U.S., but after that, those lands, any lands they purchase, are going to be held as fee simple lands, subject to state jurisdiction. Another aspect of the deal that they weren't very favorable toward right now. So again, learn from that experience. If that's what's put on the table, you say, you're not going to do what you did to us, what you did to Maine. We know what happened there. You have over 50 years of experience of post-colonial self-determination and decolonization movements to build upon. You can design, you can build, you can assert the best practice in the world. You can become the best practice for a government-to-government relationship for a people who aspire to self-determination. Also under that act, you'll notice that the tribes are subject to all the duties, obligations, liabilities, and limitations of a municipality. They're not an Indian tribe. They don't have the same powers as federal Indian tribes. They don't have a recognition of their inherent sovereignty. They're basically treated like Portland, Maine. And as you'll note, they don't have the same sovereign immunity as tribes. The other thing that, an aspect of the deal that's reminiscent of the Akaka bill that they're very sorry for now and are working very hard to change, and actually Jim's report as special rapporteur with respect to the Maine Indian Settlement Act really singled out this provision. It's probably the worst provision in there. It's probably one of the worst provisions that was included in the Akaka bill, and that is that they are subject to the same federal laws that cover other federally recognized tribes up until the date of their recognition, 1980. After that, they have to get specific mention in a statute to get some of the same benefits and powers that Indian tribes have. And so really all that has to happen is 2 of Maine's senators or 1 of their congressmen has to object and say, I'm not going to allow my tribes to be in that bill. And they're out of luck. So again, an important experience to learn from. They also have to make state payments in lieu of taxes. So watch these guys. Watch out when they come to you and be prepared. So, thank you. Okay, finally, Canada's comprehensive claims process is another one that you should take a look at. It has some good aspects, but it has some very ugly aspects. It unilaterally ends the banned status of Indians who participate in these treaty negotiations, groups them into treaty groups that they really might not necessarily have any ethnographic affiliation, but the government dictated the terms of negotiation. If you don't get into this form, we're not going to deal with you. Another, again, a municipal model of government. This is going to be one of the things that you're going to have to really fight over, okay? If you look at the Maine Indian Settlement Act, if you look at Canada's comprehensive claims policy, what these are the lessons that governments have learned about dealing with indigenous peoples when they want to terminate them. And so one of the things that they always try to get rid of is your claim and your right to inherent sovereignty and turn you into Honolulu, subject to the same basic laws. You don't have to let that happen, and you can cite those precedents of indigenous peoples who have refused to do that and those who have who regret it. The other thing that Canada does is modify your rights. So rather than extinguish your rights, Canada says if you agree to a treaty with us or any sort of government-to-government relationship, we won't call it extinguish, we're going to call it modification. And here's something I want you to recognize, and this is the most important thing, I think, the takeaway that from my talk about these agreements. It doesn't matter what words the government might use in their negotiations with you. Don't let them extinguish your right. Part of your right of self-determination, recognized by numerous international human rights bodies, but by the Human Rights Committee in its 1999 comments on Canada. The committee specifically condemned any attempt by governments to force you to extinguish and surrender your rights in exchange for an agreement for a government-to-government relationship. And so in those negotiations, you have that human right. And there's nobody on earth that can take that away from you unless you would agree. And I know enough about the Native Hawaiian people from what I've seen today and my own research and the time I've spent in international forums, that's something you'll never agree to is the extinguishment of your rights to self-determination. So I wish you the best, and we're here to help you. Thank you.